James Smith. I live at 1300 Rosewood Avenue in Rockingham. I just want to ask the question because I wasn't at the other meetings and I don't have the ordinance, but I did read in the paper about issuing a license for a bar owner. I just want to know, is that issuing an alcohol license or issuing a general license for working through the city? Because all my research shows me that alcohol license is issued by the state. And I just needed that clarification, whether that's just a general license or alcohol license.
The city attorney will respond.
The license would be to operate a bar, tavern, or nightclub. It wouldn't have anything to do with alcohol.
Wouldn't have anything to do with alcohol. So you're saying that a club that's in fraction of some of you can actually lose that license and cannot operate your alcohol license in the city anymore?
Well, you couldn't operate the bar, tavern, or nightclub. Now, the alcohol license, as you noted, is issued by the state, and that would not be effective by this ordinance.
By this ordinance. It's just for the actual business.
That's correct.
Okay. Thank you.
Thank you, sir. Any other member of the public?
Since that question was raised,
I don't think you need to, but we're going to ask you.
I'm Leonard Wiggins, Secretary. The question I like, how can we use our alcohol license if we don't get the bar and tavern license? I like for that question to be addressed.
Charlie?
It would be difficult.
What was the answer?
It would be very difficult.
I'm Sam Taylor, 509 Fall Road, and I think I'm speaking on some other things rather than the ordinances for liquor, but I'm speaking on noise and commotions and things that go on after midnight from these clubs. We live about 2 blocks away from 2 nightclubs, and as long as we've been living there and the clubs have been in that location, we've had to call the police almost every week, sometimes twice a week, for loud music that's coming to our home. They've been and still are a real nuisance to us. After calling the police department, they seem to cut music down some, but just about closing time they crank it back up, probably as high as they can get it again. The situation doesn't get any better. About 2:30, 3 o'clock in the morning, they leave the club and migrate right down Falls Road with a continuation of loud music, horn blowing, hollering out the windows, revving up the engines and speeding through the intersection. These people have no regard for the neighborhoods they pass through. The police department has used their valuable time in monitoring and actually putting their life on the line when they're called in these nightclubs. After all the commotion about 3 o'clock in the morning or later, we feel that we've been out all night ourselves and we have to go to work in the morning or go to church. This absolutely lessens the quality of life. These club owners have a right to have clubs. However, their right ends when they infringe on peace-loving, tax-paying citizens. These clubs need to be located away from the neighborhood, and I ask, how long would we have to endure this situation? If any one of you had put up with this situation, I'm sure that you would take care of it. I ask you to do the right thing as a city council who represents all the citizens of Rocky Mount. Thank you.
Thank you, Mr. Stanley.
Mr. Mayor,
Yes.
I would like to ask someone from the staff to address the question that Councilmember Blackwell posed, because I don't think we ever actually discussed the applicability of that particular section to someone who might be a current licensee or operator business that falls under the ordinance as proposed, and how it would impact them if they have a status that's set forth in the ordinance. And that's something that I think that we need to address before we move forward.
Peter, can you address that?
Is the question about licensing existing businesses?
The question is about a licensing existing business, but what if you have an existing owner and under section 4A, they have the status that's set forth with regard to past violations?
excuse me, before you finish, that concerns me. I can understand A2, those are very clear, but A3, a violation of any ordinance regulating bars, taverns, and nightclubs of any city, county, or state, that is more concerning to me.
That section in there, yeah, well, we haven't had an ordinance that regulates bars, taverns, and nightclubs in Rocky Mount, really, so I don't know what that.
So there would be no precedence against.
Right. There are incidents at bars and taverns and nightclubs, but we don't have an ordinance now until unless this one becomes enacted that regulates bars, taverns, and nightclubs.
So in effect then, unless you have one of these other, I don't know, Chief, what you call those kind of offenses, assault, battery, robbery, obstructing justice, carrying a deadly weapon, handgun violations, controlled dangerous substances, gaming violations, nudity, sexual display, obscene matter violations, pandering, sexual offenses, theft, or any felony. Those are the only offenses that could shut a club owner down at the onset, because we do not have precedents against which to enforce about a violation of the ordinance, because we don't have an ordinance yet.
Excuse me, Claire.
Within 2 years.
Within 2 years.
Yeah.
So give
It's
somebody.
further limited by time.
Excuse me, clarifying question then. On page 8, item B for A3, it specifically says a violation of any ordinance regarding bars, taverns, and nightclubs of any city, county, or state. So it's not just talking about violations of any ordinance that we might have had, and we didn't have one, but if another city, county, or state had an ordinance and they had been convicted, not just charged, but convicted of violating that ordinance, it would apply.
So,
Any other, yes,
point of
Councilmember
clarity.
Watkins.
So we're talking about making this effective with any renewal licensing. Once we pass this ordinance, this will not become effective, it will not affect current licensed bars, nightclubs, and taverns, or would it affect them once they apply for renewal? Question.
Peter, can you address that?
Yeah, we would, yeah, would come into play, yes, it would come into play during the renewal. So, in other words, a license is issued and then reissued and reissued and reissued, and new application, so this section would kick in with a year from now.
Well, they don't currently have such a license, so there would not be a renewal until the point at which they applied for and were received a license, right? And I guess the question is, if you're already existing, at what point are you required to apply for?
Well, if you're existing, what this says is that you would have until June, this coming June, to make application.
Right.
You would make application, and that license then would, granted, would go a year, July 1st the following. And then you make reapplication and reapplication.
Mr.
So-
Rhodes.
Yeah.
What a follow-up question.
Yes.
Can you press your button when you're speaking, Ms. Watkins?
Okay. So then, any one nightclub owner or manager operating a facility now, and who currently have a felony or any of these charges that we just read, after they apply for a license under this in June or July, then any past criminal record, would that come into play, or would it be ongoing from that point? Would it start with the first renewal?
Mr. Barton?
I believe it would start with the first application. There is,
So new charges, not past criminal history.
Is it, I think our question was, is it new charges or any kind of past history?
Right.
if somebody has, if I'm understanding the question, it would be if somebody has a felony conviction, say within the last 5 years of
Yes, sir.
would they be, would it be possible for them not to get a license? And I think it would be possible not to get a license, for the license not to be approved.
Mr. Mayor,
Yes, Councilmember
I
Williams.
have a question I'd like to address to Mr. Rhodes. And I think that the issue that's being raised by all these questions is that if we have, by virtue of this licensing scheme, if we have someone that is adversely impacted that's already in operation, would that not be an ex post facto application of the ordinance and the other issues that might abound? And can we do that? That's the legal,
I don't think it's an ex post facto. It's not effective for current operators until June 30th. And then they would, under this ordinance as it's written now, they would have to apply for a license, and if they have a felony conviction, then that would be grounds for not issuing a license. Now, the chief could still issue it if he saw fit to, but that's a grounds for not issuing a license.
Did that answer your question? Is there any other question?
Yeah, and that sort of clear, that last point is that the chief has discretionary latitude to make a decision on a case-by-case basis according to who it is, what the infractions are. Is that correct?
He does insofar as issuing the license. He has almost no discretion or very limited discretion in not issuing a license. In other words, he would have to find the felony conviction or one of these things listed not to issue the license.
Is there any other member of the public